we'll kind of change. And Keith, you mentioned something that I want to dive deeper on that we talked about last time. And I actually got a few questions from some viewers who did some research into some of the content you put out. And that is probably, I would say, one of the top 2 or 3 issues that men deal with nationwide, probably really worldwide, in family court, and that is domestic violence allegations. And you talk about ad nauseum in your content on being proactive and prosecuting and really going after and investigating flimsy and false allegations. So a guy steps into your office and says, I have a protective order, and I have a hearing in a couple weeks, and I've been accused of domestic violence, whether it be physical or verbal, or they're saying I've hit the kids. What is the what are you going to tell that guy, and then what are the first things you're going to do once they retain you to help them with that matter?
Okay, so the first thing I've got to ask is, let's look to the allegation. Is there anything in the allegation that doesn't meet the statute? If that's the case, then, well, we've got a good motion already, right? The second thing I'm going to say is there's 3 steps to this. 1, okay, your first thing is to look at history of communication, okay? Let's look at a prolonged history of the 2 of you communicating. Does that prove up a domestically coercive, a violent relationship? Let's see how many times she tells you in text messages that you're a good dad and does not mention some form of domestic violence. 2, let's look very specifically at the date of the offense and the communications related to that specific time frame. And I want to see the physical evidence, I mean text messages, related to that time frame, okay? Because if 6 hours after she's alleging it, you guys are all nice, I mean, that's very relevant to a judge, right?
Can I tell a quick story on that specifically?
Oh, of course, yeah.
I had an instance where mom left with the children and then filed for a domestic violence restraining order with very, very graphic, specific allegations. So I tell him, hey, I need all the text messages. I need everything. And he was like a little bit hesitant at first, and I didn't know why. And I'm like, I need everything. And I start digging into the situation, and just hours after she alleged this incident occurred, she had offered, one of her friends was over and had offered to have a threesome with him. So sometimes it's the things you hear as a family attorney. So I'm sitting there and I'm like, okay, so she's alleging at 2 p.m. that you slammed her head against the wall, choked her out, and punched her a few times, then just got up and walked away. In 3 hours, she's like, hey, my friend's over. You want to join us in bed? Doesn't make any sense.
Yeah.
All right, sorry for that interruption, but I had to.
I call it time stamping the allegation. I mean, let's look at it and in terms of when the date of offense is, and let's figure it out. Now, obviously, you have a mode of vehicles in order to impeach her. And unfortunately, a lot of times, we're going to be trailing that protective order. We're not going to get the fucking prosecutor to dismiss this thing, when we show up at arraignment. You're going to have to sit. You're going to have to wait. We're going to trail the protective order. You're not going to talk to her for a little while. Whatever. And it does impede custody. That's the worst part of it. Yeah. I mean, frankly, that's the worst part of it. And that's why a lot of these women's lawyers are telling them to abuse the court processes because, hey, the status quo Brian was talking about. We can develop a status quo, blah, blah, blah. And it's scary to go to court and get a final protective order. It affects your career, etc. But the reality of it is you need to let us investigate it. We need a deposition. We need written discovery. We need them to produce it because otherwise, guys, it's going to kill you. I mean, it's going to affect the ability that you see your kids for years to come unless we can put substantial change of conditions and change the underlying decree. It's going to affect your employment when that protective order comes out, and then some employers like, oh, you've got a protective order. If you cop to a misdemeanor that you didn't do, golly, domestic violence misdemeanor? Come on. And then let's talk about the protective order statutes. The federal government here has imposed serious restrictions on your right to even own a firearm. And Brian's an expert on that, so I mean, I'll let him talk.
I mean, if you have a final protective order against you under Oklahoma law, you can't have a carry permit. You can't purchase a firearm under federal law because you will not pass the NICS test check. And with a final protective order, in most cases, you can't even possess a firearm. Like basically, if you have a gun cabinet, you're going to empty that thing out because you are now you're now legally prohibited from possessing it. And what's interesting too is the way that they're defining what counts as a firearm for the purposes of a protective order could also include things like a crossbow. So if you like to bow hunt,
not the crossbow. That
Red Ryder that you gave your
BB
kid.
gun.
I mean, like literally, you can't even have the Red Ryder you gave your kid at your house.
And not only that, but an unfortunate thing, at least in Oklahoma, and I mean, I don't know if this is the same way in California, but the way the laws are written in Oklahoma, the problem you run into with these protective orders is it's almost like playing with house money. You throw the dice on a protective order. If you lose the argument, the protective order gets denied. There's really not a lot of penalty, except if it's really an obvious abuse. And convincing a judge to award you attorney's fees in a situation like that, or trying to go after her for some other penalty, you're fighting an uphill battle, even if you win the argument at the protective order hearing.
But then you're res judicata on the other, right?
Right. If she gets it, she's got a res judicata argument on custody that it is against the best interest of the child for you to have anything other than supervised. Because it's already been found that there's enough there to get you a protective order. So there you go.
But it depends, obviously, guys, because in Oklahoma, at least, it's present in the home, and so the res judicata argument is always going to be leaned on you if you got the final. If you were dumb enough to show up to that protective order hearing without a lawyer, I mean, it's dumb. Okay.
Yeah.
If you ask the judge to put a protective order hearing on, you're basically asking them to rubber stamp a protective order, unless you've got some good stuff. Okay. If you were dumb enough to do that, now we're in the custody battle. Res judicata doesn't actually mean in the home at the time of the custody order, but you've got to make that argument to the judge. A lot of times, it's not happening. I mean, right?
Yeah, you're fighting a serious uphill battle in that situation. And it's not impossible to win the argument, but it makes it a hell of a lot harder, particularly if you have a situation where there's some specific, something that sounds really, really bad.
Right.
I mean,
which it always does. I mean,
yeah, because they're going to write those pleadings up to make it sound like a piece of shit.
Yeah.
And the judge looks at that, and then you either they found grounds or you cop to it, and they're like, oh, you did this, and then you did this, and then you did this. Oh yeah, you're a piece of shit. Why am I giving you custody? Why am I giving you unsupervised
And you get a
visitation?
protective order, and it's grounds harassment. Okay, res judicata, and maybe your family judge says, well, that's domestic violence. Well, no, it wasn't domestic violence, judge. It was harassment. Now we've got a protective order out. And the other thing is harassment got to be no legitimate purpose. Sometimes, you asking to see your kid, that's what she's pleading is harassment.
Oh yeah, that's
and you show up to court without a lawyer, and you get nailed on that. That
I think another
destroys your custody.
Another thing guys need to understand: there's a trap that I've seen guys fall into from time to time when they show up in these dockets per se. Is they think, oh well, I'll just stick to it because I don't want to talk to her anyway, and not realizing what the other legal consequences are that go along with having that protective order. And by the time we talk to them, it's already done, and they're like, well, I didn't know it would have that effect. So, I mean, never agree to something until you have a chance to talk to somebody, because you just don't know.
I got two things on that. An irony about going in pro se. A couple weeks ago, ours is handled exclusively through family courts, and if you have an open family case, a lot of times that judge will preside over a domestic violence restraining order hearing. Well, I had a case. I got a DVRO thrown out, and we're finishing up the paperwork, everything. I hop on the elevator. A guy hops on the elevator with me. Apparently, he went in pro se after I had been up there, and he's like, "Hey, I saw you in there. They just granted this domestic violence restraining order. Uh, can you help me out?" Like, well, I can't get rid of the domestic violence restraining order now because that ship has sailed. We would have to go through a lot. And number two is the state of California, they actually statutorily in the family code, harassment, coercive control, we have one of the broadest definitions of domestic violence in the family code of any state in the country. And if you're found guilty of domestic violence by preponderance of the evidence, there's a presumption that for 5 years you should not have any legal or physical custody. So these guys who go out there, and I wish I could shake every criminal law attorney who has a dad plead down to something, but you could plead down to some very low level misdemeanor on a domestic violence case, and all your spouse, your ex-girlfriend, your co-parent, all they're going to have to do is trot that pleading in and say, "Your Honor, they've pled guilty to a domestic violence charge," and it creates a 5-year presumption. So this is something state by state. I know Nevada has the same exact law, except it is clear and convincing evidence. So it's not preponderance; it's clear and convincing. So you got to know your state's laws, and you need to talk to someone the day it happens. Not get emotional, not lash out, not do anything crazy. You need to talk to a professional and figure out what your options are, because those decisions you make, especially around domestic violence, could have consequences for the next 16, 18 years of your relationship with your child.
Yep.
Well, Mark, that California law is bullshit.
That really is.
Family Code Section 3044, it's one of the worst laws in the country, period.
That's crazy. I mean, it makes it.
So it doesn't have to, like I said, it can be, they can find you were harassing. I call them mean text domestic violence restraining orders. Basically, a few nasty texts get sent back and forth. Judge slaps the DVRO on them. Then that creates what we call 3044 presumption. And you got to go through a whole lot to be able to rebut that presumption over the next 5 years.
I mean, I get the idea of, criminalizing domestic abuse. I mean, that's one thing. That's fucking absurd.
Yeah, it is.
I mean, basically, there's no incentive to rehabilitate if you do make a mistake.
It's crazy.
It's like, you might as well take that to trial, because if you don't
5
take it to
years.
trial,
How many years is your kid a kid?
yeah,
5 years?
5 years.
Holy
Yeah,
shit.
it basically, the statute comes out and says that if you're found by preponderance of evidence to have perpetuated domestic violence, then it is presumed that it is not in the best interest of the child for you to have any legal or physical custody. And it is not an uncommon thing for a guy to come into my office and have had a criminal case, no restraining order in place, no nothing, but there's a custody case that started, and they pled guilty. Their criminal attorney advised them to plead guilty to some like simple battery or some low-level misdemeanor, but that automatically creates the presumption, because that's beyond reasonable doubt. And now we're talking about a broader definition and preponderance of the evidence. It's I had David Passara on, he's a Southern California father's rights attorney, and we talked about it. It's one of those things that the law, I get the purpose of it. Domestic violence is a serious matter, but they've created a situation in family court where weaponizing it and filing it on flimsy grounds, you're most likely, the bar is extremely low. If an attorney files for a domestic violence restraining order, they're probably going to get it granted, because you know exactly what to say. You know how to cross that bar. Like, I mean, it's probably less than 10% of DVRO requests submitted by attorneys, the temporary orders get denied. So you're already going to go 21 days without seeing your kids, most likely. And then you're going to have to deal with, do I need to set this for a long form hearing? Can we convince the judge to pull the kids out of the domestic violence restraining order? But it's become a play in California. And I've talked with attorneys out here, and a lot of attorneys who do what we do. And the question is, I'm like, do attorneys, when they represent these women, are they digging for this domestic violence? Are they digging for something they can call domestic violence to get an upper hand in this? That's really what's occurred in California. And quite frankly, I think part of the backup in the family court system is specifically because of this issue.
You know, Mark, I was one of the most aggressive prosecutors in terms of domestic violence. I had, very little toleration for it. But at the same time, you got to recognize what the incentive is for these people to make those allegations. And, even as a prosecutor, you're looking at it, and your system, it appears to me like far, far, far more.
Well, prosecutors aren't involved. We're not even talking. This is, if you file for the DVRO, that party that files, the protected party, is prosecuting that themselves. So it's another attorney, it's this person pro se going in front of the judge saying, I need this protective order. So there's no bar to get over. It can just simply be filed. And the TRO can be granted without a response. It's granted without a response. It's just granted on the face of the pleadings.
He signs an affidavit. The judge says, okay, that's enough. Let's see it. Right?
Yeah. You submit, literally what you do out here is you submit the petition, and then you submit what you want the temporary orders to be, and you submit what you want the orders to be after hearing. You submit those forms to the judge. And like I said, I would say single-digit percentage of requests get denied. In general, you're going to get that box checked on the front page of the DV-110 is the form that says, or DV-109 that says all these requests are granted until hearing.
Similar to how our protective orders work with an emergency judicial protective order, is basically the judge will rule off the pleadings. I mean, at least here, you actually have to fact plead it. So you have to, in theory, you have to show, okay, here's why. But in practice, they're very frequently rubber stamped.
Well, and frankly, people who don't show up get fucked.
Mm-hmm.
People who show up without a lawyer, it's a he said, she said, preponderance.
If you show up late, you can get fucked that way.
Yep.
And I think there's a failure to appreciate how serious this is, and there's really not a huge penalty for abusing these things.
Yeah, no.
I mean, you might get your ass chewed by the judge. I've seen that happen before.
Technically, you can get attorney's fees. That's rarely ordered.
Yeah.
So we have something, attorney's fees in California are thrown around left and right. We have something where it's screwy with the law. So if you file for that domestic violence restraining order and you prevail, you can go after attorney's fees.
Yeah, that's good.
Statutorily, it doesn't explicitly address if a domestic violence restraining order is filed against you and you prevail and get it thrown out. It doesn't explicitly give you a path to request attorney's fees.
Same here. You've got to go under the case law.
Yeah, I mean, that, but you have to basically show it was frivolously filed and there was no victim.
No victim.
Yeah, and that's a very high burden. And the other thing is you get a situation where judges don't want to discourage victims from filing these. So you're really talking about having to show a case where it was obvious abuse. I mean, the case that we always cite to in our motions is the Pearman case.
Finger.
Yeah. Well, and Pearman, basically what the nut of that case was is you had a situation where it came out in evidence undeniably that this person had filed a protective order specifically to give her friend an advantage in custody litigation. And in that case, attorney's fees were awarded. But I mean, that's
wasn't a domestic litigant, so it's another.
Yeah, and I mean,
there's a bar to cross. Yeah.
I wanted to comment on another problem. I don't know if you're seeing this here. I know I see it a fair amount, and I think you see this a lot too, where you have judges in protective order court who allow evidence to be considered that wasn't pled into court. Like they'll come and plead in like harassment or some particular incident that they say justifies this protective order. But then when you actually get to the hearing, they're bringing in a bunch of other crap that they never mentioned in the pleadings. And it's a coin toss whether the judge will let that in or not. A lot of times they will, and then grant a protective order on something that was never pled into court.
Yeah, that's something we see out here. You show up, and a lot of times you'll get someone that pro se they filed this domestic violence restraining order, and they attach some random documents, a couple screenshots of text messages, and you look at the client and you say, okay, we're going to show the full roll of text messages. We have this couldn't possibly have happened, and you show up in court. They have an attorney and they have a binder of evidence, and they're like, Your Honor, this is what we're like. We have 21 exhibits, and we're going to have 3 people testify. And it's like, these people weren't even mentioned. And in California, you file for that, you have 21 days. The only mechanism of discovery you have to get to gather any information in that 21 days is to basically immediately notice a depot and serve it upon the party. Because if you file any, if you want to file any written discovery requests, it's 35 days in California, so they don't have to respond until after the hearing. So the only method
here in Oklahoma, I mean, yeah, we'll continue an emergency and do discovery. We can do depositions and written discovery.
Well, the struggle is out here. If you continue that matter, you may not get back on calendar for 4, 5, 6 months. So obviously there's a huge deal of seriousness to the matter and the consequences, but you're sitting there and it's like, especially when you look at a pleading and you respond to it and you're like, there's nothing here. We have evidence that contradicts all this stuff. And then they show up and you're looking at them like, hey, we're going to have to wait 2, 3, 4, potentially 6 months before you get your day in court. And we're going to have to beg the judge and plead with the judge to remove the kids from this restraining order in the meantime.
Yeah. Oh, the judges will remove the kids almost as a matter of course. If you don't file an emergency custody order here in Oklahoma, those judges are going to remove those kids.
9 times out of 10, yeah.
Yeah, I mean, unless it's like you're filing a protective order because somebody sexually abused a kid or something. I mean, that's like, they're going to throw out the protective order.
Yeah, the only other exception I've seen is if you're talking about a particularly egregious example of violence where the kids were there. I mean, I think I had one involved where there was an allegation involving a firearm like that, but again, it's not the typical situation.
Yeah, because they're going to at least order supervised for even the shittiest dads here, I think. I mean, yeah. Most times they're going to give, like, you got the worst guy shows up to your office. He's probably going to get supervised visitation.
Maybe not even get that. I mean, it may be one of those deals where the judge will just say, well, we'll put him on weekends and see how that flies.
This is why I was so surprised about the rating that was given to Oklahoma last time we were talking. Like,
I'm sure based on it, and they're due to update them. I would be very, very shocked. I think it said Oklahoma, they were a D+ with the facts, findings, and conclusions of law. And based on how things operate now, just the facts, findings, and conclusions, if you deviate from the joint, that right there come November 1st probably puts Oklahoma in the B range. Just having that simple fact, because with the work I do for the Fathers' Rights Movement, we look at 3 things when it comes to custody litigation. We want a presumption of 50-50, then the burden of proof we want, like Arkansas has, which is clear and convincing. Kentucky has preponderance of the evidence, and then we want facts, findings, and conclusions of law. Like the state of West Virginia in 2021, they didn't get 50-50, but they got facts, findings, and conclusions of law if the judge orders 35% or less custody to one of the parents. So basically, the judge has to justify as to why he's limiting access of one of the parents.